So I was watching the Harpy, and I found this to be interesting for a very, very simple reason. It wasn't because of the standards for the protection of personal information of residents of the Commonwealth that requires the protection of any data that includes social security numbers or driver's license or state issued identification card number or financial blah 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 information. It requires it, the unauthorized acquisition or unauthorized use of unencrypted data, I should say. It requires the duty to protect and the standards for protecting personal information. It requires them to protect it. I could go over that, but I won't. I could go over the general trespass law for Massachusetts, which allows the RMV to trespass people who they want to, basically, and the limiting factor is whether or not you're there to engage in the business that that particular facility is lawfully dedicated to. It's not about what you want to do. It's not about how legitimate you think your purpose is. It's what is the purpose of that building. The purpose of that building is for people to go in and conduct transactions regarding their vehicles. That's what the purpose of that building is. And the government can restrict the use of that building for that purpose. But I won't talk about any of that. I'm going to talk about the Supreme Court has already ruled. Because my God, this woman is ignorant. She is ignorant. She marches out there professing that she is going to learn these people up something good. She ends up getting trespassed. She's lucky she didn't get arrested for criminal trespass. She's got her little sycophants down there. Oh, good job holding your own. She didn't hold her own. She got backed right out of there. She caved because she knew she'd get arrested. But the Supreme Court has already ruled. Number one, this guy's trying to... she says she has a legitimate purpose. And then she says the Supreme Court has already ruled. Then he says that you can go in there and film, and it didn't quite catch that. And she says this is a government building. You can listen to it for yourself. It's from 1550-ish to 1607-ish. You can listen for yourself to make sure that I am not mischaracterizing it. This is an actual Supreme Court ruling. It's built upon, I don't know, 40 years or so of, oh, maybe more than that, 60 years or so, 50-ish years of jurisprudence about non-public forums and the test that would or does or could allow filming in it or other First Amendment protected activities in it. This is from 2018. I picked it because it's new. It's brand new. It was filed June 14th of 2018. That's pretty good, right? You can't say it's been overturned or anything like that. In this particular case, there was a ban. Minnesota, was it Minnesota? I think it was Minnesota. They had a ban on people going into polling places. These are government buildings, going into polling places wearing political insignia. So it's a ban on political speech in government buildings. And the outcome, the eventual outcome was that the ban was unconstitutional. But let's look at the test, because while it was unreasonable for Minnesota to ban political badges, buttons, or political insignia in a polling place, let's look at the actual test. But the ban applies only in a specific location, the interior of a polling place. It therefore implicates our forum-based approach for assessing restrictions that the government seeks to place on the use of its property. And generally speaking, our cases recognize three types of government-controlled spaces: traditional public forums, designated public forums, and non-public forums. In a traditional public forum, parks, streets, sidewalks, and the like, the government may impose reasonable time, place, and manner restrictions on private speech, but restrictions based on content must satisfy strict scrutiny, and those based on viewpoint are prohibited. The same standards apply in designated public forums, spaces that have not traditionally been regarded as a public forum, but which the government has intentionally opened up for that purpose. In a non-public forum, on the other hand, a space that is not by tradition or designation a forum for public communication, the government has much more flexibility to craft rules limiting speech. The government may reserve such a forum for its intended purposes, communicative or otherwise, as long as the regulation on speech is reasonable and not an effort to suppress expression merely because public officials oppose the speaker's view. This court employs a distinct standard of review to assess speech restrictions in non-public forums because the government, no less than a private owner of property, retains the power to preserve the property under its control for the use to which it is lawfully dedicated. Nothing in the Constitution requires the government freely to grant access to all who wish to exercise their right to free speech on every type of government property without regard to the nature of the property or to the disruption that might be caused by the speaker's activities. Accordingly, our decisions have long recognized that the government may impose some content-based restrictions on speech in non-public forums, including restrictions that exclude political advocates and forms of political advocacy. A polling place in Minnesota qualifies as a non-public forum. It is, at least on election day, government-controlled property set aside for the sole purpose of voting. The space is a special enclave subject to greater restriction. Rules strictly govern who may be present, for what purpose, and for how long. And while the four-justice plurality in Burson and Justice Scalia's concurrence in the judgment parted ways over whether the public sidewalks and streets surrounding a polling place qualify as a non-public forum, neither opinion suggested that the interior of the building was anything but. We therefore evaluate MVA's First Amendment challenge under the non-public forum standard. The text of the apparel ban makes no distinction based on the speaker's political persuasion, so MVA does not claim the ban discriminates on the basis of viewpoint on its face. The question, accordingly, is whether Minnesota's ban on political apparel is reasonable in the light of the purpose served by the forum. If you apply that to the RMV, the Registry of Motor Vehicles, you have to assess whether the restriction is reasonable in the light of the purpose served by the forum. It's a content restriction. They don't care why she's filming. That's not the reason that she's being banned. They don't allow filming. without prior permit, and they can do that. And it is reasonable because of the standards for the protection of personal information of residents of the Commonwealth. It's reasonable in the light of the purpose served by the forum. The purpose served by the forum is to register your vehicle. So when Little Miss Uneducated Harpy is going to educate people, she may wish to become slightly more familiarized with the First Amendment before she does so. And she may wish to stop saying stupid, asinine things, like that the Supreme Court has already ruled that she could film in government buildings, because she may not be able to. In fact, many times she won't. Thank you for watching, and have a great evening.